The moment your personal net worth clears $2 million, you stop being an employee in the eyes of the U.S. civil litigation system. You become a recoverable asset. Your title didn't change. Your responsibilities didn't change. But your legal exposure profile, quietly, algorithmically, without a single memo from HR, just escalated into an entirely different risk category. Here is the architecture of that escalation. The average civil lawsuit, targeting a named corporate executive in 2026, carries a plaintiff demand of $1,400,000 to $4,700,000. That is not a company-level demand. That is a personal demand against your brokerage accounts, your real estate equity, your deferred compensation, and the vested RSUs sitting in your portfolio right now, and your company's directors and officers policy will not cover the full exposure, not even close. Standard D&O insurance. The policy your general counsel will cite when you ask about personal protection is structured in 3 coverage layers: Side A, Side B, and Side C. Most executives assume Side A, the layer designed for individual protection when the company refuses to indemnify, is a bulletproof personal shield. It is not. Side A coverage in a standard corporate D&O policy carries exclusions for regulatory conduct, fraud allegations, and critically, insured versus insured claims. That last exclusion means if your company or a co-director files a cross-claim against you during litigation, the policy that was supposed to protect you actively steps aside. The policy that your company paid for, using your employer's budget, contains a built-in trapdoor. And the moment you signed your offer letter, without negotiating a standalone personal indemnification agreement, you handed the insurance carrier the key. This is where the systemic design becomes measurably predatory toward high-earning women specifically. Female executives in 2026 are disproportionately appointed to what institutional governance researchers term glass cliff positions, high-visibility leadership roles during periods of corporate distress, regulatory scrutiny, or reputational crisis. A 2023 study out of the University of Exeter confirmed that women are statistically more likely to be selected for board seats or divisional C-suite roles when the organization is already under financial or legal stress. The optics are favorable. The legal exposure inherited with the role is not disclosed up front. She walks into a vice president of operations title or a board directorship. She is photographed at the earnings call. Her name appears in the 10K filing. And every plaintiff attorney scanning public corporate disclosures for named defendants with attachable personal assets has just added her to a list. At $2 million in net worth, she clears the plaintiff side threshold for a worthwhile named defendant. Below that number, litigation economics rarely justify a personal pursuit. Above it, she is operationally profitable to pursue, independent of whether she is actually liable. This is not hyperbole. This is plaintiff-side litigation calculus taught in every U.S. law school. The system does not target guilt. It targets collectability. What makes this compounding is the structural silence around it. The negotiation tactics her male counterpart deploys before accepting a board seat. Demanding a personal indemnification side letter. Negotiating a standalone excess Side A policy, funded separately from the company's master D&O tower. And structuring personal assets inside a domestic asset protection trust or an offshore Cook Islands trust structure prior to accepting the role are conversations that happen in private counsel offices, not in onboarding packets. They are institutional knowledge, passed laterally between professionals with access to the right legal networks. And because women remain underrepresented at the senior advisory levels where that knowledge circulates, she never receives the prompt to ask. She accepts the role. She delivers the results. And she carries the asymmetric personal liability of the position, without the asymmetric legal armor that the role demands. Every quarter she remains a named officer or director without a standalone indemnification agreement. Is a quarter her $2 million, her $3 million, her $4,700,000 in accumulated net worth sits exposed at the precise threshold where she becomes operationally attractive to pursue. The superwoman expectation compounds this silently. She is managing corporate restructuring timelines, while simultaneously absorbing the financial weight of her household as the primary or sole high earner. the psychological bandwidth required to audit her legal exposure profile, to sit down with a personal asset protection attorney, and rebuild her financial architecture before the next role transition, simply does not exist. Inside a 70-hour executive workweek, the system is not designed to give her that bandwidth. It is designed to keep her producing at maximum capacity until the litigation event creates the interruption. Here is the structural revelation that ties this entire exposure architecture together. Call it the collectability cliff. The collectability cliff is the precise net worth inflection point. $2 million in 2026 U.S. plaintiff-side litigation economics, at which a named executive transitions from a judgment-proof practical target to a premium recovery opportunity. Below the cliff, pursuing a named individual is economically inefficient for a plaintiff legal team operating on contingency. Above it, your personal balance sheet funds their business model. The institutional fix is not defensive. It is preemptive structural repositioning, executed before the role acceptance, not after the subpoena arrives. The single highest leverage legal strategy available to a female executive approaching or crossing this threshold is the negotiation of a personal indemnification side letter, combined with the immediate funding of a domestic asset protection trust. In a favorable jurisdiction such as Nevada, South Dakota, or Delaware, ADAPT legally repositions personal assets out of direct attachment range while preserving your beneficial interest, provided it is structured at minimum 2 years before any claim arises, combined with a separately negotiated excess side A policy, a personal D&O policy you own, not your employer. Your personal balance sheet stops being the recovery vehicle. You are not hiding assets. You are architecting your financial infrastructure with the same institutional rigor that your employer uses to protect its balance sheet. Every Fortune 500 corporate treasury does this. The only question is whether you have extended that same architectural discipline to your personal financial perimeter. The precision required to execute this before a role transition demands a personal asset protection attorney and a fee-only financial advisor working in concert, not your company's legal team, whose obligation is to the entity, not to you individually. The legal exposure draining your net worth from the outside is only one axis of the wealth compression, hitting you at this income tier. There is a parallel extraction happening from the inside, embedded inside the professional identity you have built, and the operating costs required to maintain it, the attorney fees, the wardrobe infrastructure, the conference circuits, the executive coaching subscriptions, the premium everything that signals you belong at this level. They are not just lifestyle costs. They are a tax on your perceived executive legitimacy, and they are compounding against your actual wealth-building runway in ways the standard financial plan never accounts for. Click the video on your screen right now, and let's dissect exactly how the invisible $50,000 per year executive maintenance cost is quietly eroding the same net worth you are working this hard to protect.